So a case dealing with machine gun bans and the GCA's restrictions on those items is now in front of the Supreme Court. This is a critical case, so let's talk about what is now happening. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe to the channel. Also double check to make sure YouTube is not unsubscribed you, because they love to do that, especially on two-way channels. And then also I want to thank one of the main supporters and sponsors of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. Their supplements are amazing. I love their protein powder, their pre-workout, all of those things. But one of the really cool things about 1st Phorm is they're pro-freedom, pro-America, and they support the Second Amendment and what we talk about here on the channel. So if you're interested, check them out using the links down below. And if you order something $100 or more, you can get free shipping on that order. As I mentioned in the intro, in this video, we're going to be talking about a critical case that is now in front of the Supreme Court, and it deals with the Gun Control Act, the GCA, and its restrictions on machine guns. This is involving machine gun bans and trying to strike them down using the Second Amendment. Now, recently we know that we received a decision out of the 10th Circuit Court of Appeals, and it upheld the GCA's machine gun restrictions despite the Second Amendment and those challenges used, against it, and some of the Supreme Court's recent rulings in cases like Bruen, Rahimi, and Heller. Now, this all comes after the Trump DOJ continued to argue against the Second Amendment in this case, and also some other machine gun challenges that were pending in other courts. You may recall that 2 district court judges recently dismissed machine gun possession charges using the Second Amendment. Now, the first came in a case called U.S. versus Morgan, and in this Morgan case, which is now seeking Supreme Court review, a federal district court judge in Kansas found that the machine gun possession charges were unconstitutional, and they said that they were a violation of the Second Amendment, and it was a violation as applied to Mr. Morgan. But now this critical Gun Control Act / machine gun ban case is seeking Supreme Court review. This case asks for the Supreme Court to strike down what the 10th Circuit said, and also finally clarify for lower courts what type of arms are in fact protected by the Second Amendment. Now, in this case, Mr. Tamori Morgan was charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. Specifically here, Mr. Morgan was charged with possessing an Anderson AR-15 that they argued was full auto, and then he also had a Glock switch. So it's the possession of those 2 items that got Mr. Morgan charged and convicted, and eventually on the lower court level, he moved to dismiss the case based on the Second Amendment. On review, the district court judge actually ruled in favor of Mr. Morgan, striking down those GCA violation charges that were brought against him. Now, when looking at the Supreme Court's precedent in Heller, this lower court judge found that the government relies on Heller to argue that machine guns are not covered by the plain text of that amendment. The Heller language cited by the government is unavailing. First, he stated, the government's interpretation of Heller relies exclusively on dicta, but he states machine guns were not at issue in Heller. Second, the government's interpretation would run directly counter to the essential analysis in Heller. He stated, just as the Fourth Amendment applies to modern searches, the Second Amendment applies to all arms that did not exist at the country's founding. So the court rejected the federal government's argument that Heller supports this complete ban on machine guns and supports these type of restrictions. Now, it's important to note that in this Morgan case, the federal government at that lower court level put forward very little evidence to try to justify this federal law. Instead, they seemed to kind of get lazy and think that the analysis would kind of end after the historical review, or really end even before that, and that they could beat this just based on the textual arguments that these are not arms. But after losing at the district court level, the federal government at that time decided to appeal to the 10th Circuit, and they asked for the 10th Circuit to reverse the lower court. So despite the new administration and the Trump DOJ having control of this case, they continued to argue against the Second Amendment. Now, during the oral arguments, the Trump DOJ's attorney relied heavily on Heller as a basis for banning machine guns. They pointed heavily to Heller's dicta about M16 rifles and the like being restricted and being dangerous and unusual weapons. Now, there was also a lot of discussion about how to apply Bruen in that analysis, and if in common use for lawful purposes should be applied at the first step of the analysis or the second step when you're looking at text, history, and tradition. Like I mentioned, the 10th Circuit agreed with the Trump DOJ and found that machine guns are not protected arms by the Second Amendment. Well, now all of this is up for review, and Mr. Morgan has filed a cert petition to the United States Supreme Court asking for them to finally address this issue. In this petition, he states that when it comes to the Second Amendment jurisprudence, confusion plagues the lower courts. As relevant here, he states, the lower courts are conflicted over how to determine whether specific weapons qualify as arms under the Second Amendment's plain text. In Heller, this court logically stated that all firearms constitute arms under the Second Amendment. Yet below, the 10th Circuit held that Tamori Morgan's handgun and pistol did not constitute arms under the Second Amendment's plain text because the firearms could fire automatically. According to the 10th Circuit, Mr. Morgan's firearms would constitute arms under the Second Amendment's plain text only if he could prove that the firearms are in common use today for self-defense. And because Mr. Morgan could not meet that burden, his firearms were not arms under the text of the Second Amendment, according to the 10th Circuit. This meant that the government did not have to justify its regulation, and they did not have to justify it by demonstrating that it is consistent with the nation's historical tradition of firearms regulations as required under Bruen. They go on to state that this threshold question, how to determine what constitute arms under the plain text of the Second Amendment, has caused confusion among courts generally. That confusion will persist until this court definitively resolves the threshold question. Moreover, the issue is exceptionally important in that it involves a core threshold issue in the Second Amendment jurisprudence. That core issue affects who has the burden as well as what the party must prove to meet that burden. They state that the 10th Circuit's decision is incorrect and it cannot be true that Mr. Morgan's firearms do not constitute arms under the Second Amendment merely because they more quickly fire some rounds more than other identical firearms. And they also state that, as importantly here, the 10th Circuit's decision results in a circular conclusion that Section 922O's 40-year ban on the possession of machine guns is constitutional because Congress has banned the possession of those machine guns for at least 40 years. They state that, after all, it is highly unlikely that an individual could prove that a firearm that has been banned for at least 40 years is in common use today. And with its conclusion, the 10th Circuit erased entirely the government's burden to justify Section 922O by demonstrating that it is consistent with the nation's history and tradition of these types of firearm regulations. They go on to state that this case is an excellent vehicle to resolve this exceptionally important threshold issue. The question was squarely presented and resolved below in a published opinion. This court should grant this petition. So that is where this machine gun ban case is currently standing. Mr. Morgan and his attorneys are now seeking and asking for the Supreme Court to grant review of this case and strike down what the 10th Circuit said. They push for this case as a good vehicle for the Supreme Court to finally outline what arms are protected by the text of the Second Amendment. Lower courts continue to use a bunch of legal workarounds to state that certain firearms are not protected arms, that they don't fall under the text of the Second Amendment, despite, acknowledging that they are firearms, but they say that they're not protected arms. And this case asks for the Supreme Court to step in and correct those errors. So this is a very important challenge that is now currently seeking Supreme Court review. It's in front of them. And now we're going to wait to see how does the Trump DOJ respond to this petition. But I would state that I anticipate that they will kind of do the same thing that we've seen them already do in this case prior, and also what we've seen them do at the Supreme Court level in some of the NFA cases. They will argue that this is not protected by the Second Amendment, that these arms are dangerous and unusual, and therefore they could be restricted. So that's what's currently going on in this critical challenge. As we get more information, as this develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of these two videos here on the screen that the YouTube algorithm thinks that you'll find helpful and educational. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.